So my name is Ozzy Fonseca. I'm Director for Experience Data Research Solution Team. I want to welcome you to today's session, and I want to thank you for being here. I know there are a lot of other sessions to choose from. To give you a little background about myself, I'm a certified information privacy professional, and over the last few years, my team and I have worked with more than 2,300 data loss incidents, including the deployment of large-scale breach notification services and programs, also incident response call centers, as well as providing state-of-the-art credit monitoring and fraud solution services to companies who have either our help in the past. Before I worked in my current role, I worked in the call center industry implementing data breach programs and response plans from a customer service perspective. We have a great presentation ahead of us with a fantastic panel that I'll be introducing more formally in just a moment. The way that we have structured our presentation is as follows. We're going to begin with an overview of key high-tech provisions, followed by business associate consideration, as well as marketing considerations, and some lessons learned for those 2 points. We're going to follow the presentation with risk assessment best practices, and finalizing with electronic access compliance best practices. We'll then, after that, time permitting, open up for questions. Our panel will begin introducing Peter Adler. Peter is the Chief Privacy and Cybersecurity Legal Compliance Officer at SRA International. He provides compliance with legal requirements related to privacy and cybersecurity, including fulfilling customer privacy and security contractual requirements. Peter leads establishment and implementation of corporate policies and standards for data privacy and network security. He has extensive experience in state, national, and international information security and privacy law, and is former Chief Privacy Officer for United Health Group. Also joining us today is Derek Wu. Derek is Managing Director of Revenue Cycle and Healthcare Informatics Services at Seneco Healthcare Consulting. He directs all aspects of the firm's health information technology, and information security practice. He brings to the table a depth of experience in technology, healthcare, operational process, and government organizations. He served as information security advisor to U.S. Senator Edward Kennedy's office on the proposed rulemaking panel for the Health Insurance Affordability and Accountability Act. Without further ado, let me turn it over to Peter to get us started. Peter?
Thank you, Ozzy. It's the high-tech session, but I think we're going to be a little low-tech without the sound. And thought of another comment. Please ignore the man behind the curtain. Get all these out of the way. What we're going to do today is we're going to take a very high-level view, and some of this you probably heard before. I hoped that I was going to wake up this morning and I was going to come in here and I was going to have this dramatic announcement that the rules are out. They were released this morning. But that didn't happen, and from what I hear, it's not going to happen for a little while longer. So we're still kind of looking at the rules as they are, and hopefully some of you have started to implement them where you are, or if you're a consultant or an attorney, you're helping people do that. We have, as a beginning, just an overview of the key provisions, and then we'll hone in on a couple, as Ozzy said. And we encourage questions and answers at a later time, or if you have something you can't wait, just pop your hand up. I'm sure we would be very happy to answer any questions that you might have. The first of the, and by the way, how many of you are in the process of putting some of these in place right now in your organization? Okay. And how many of you are done? Nobody, right? It's the kind of thing you don't want to get too far ahead of, because who knows what kind of curveball you're going to be given when the final regs come out. But at the same time, if you're in a large organization or an organization that moves slowly, traditionally, you want to start planting the seeds and moving it along. And I know that you have difficulty as you work this problem in your organization to keep the attention of the people at your organization, because sort of like waiting for Godot, we just aren't seeing these. I think the latest breaches may have gotten some attention about the seriousness of not complying, but I know that you're struggling to kind of keep the interest alive within the organization. The first one is access to certain information in electronic format, and Derek's going to talk a little bit about that in his session. Restrictions for disclosure for paid for medical costs. Some people call it cynically pay for privacy. In other words, if you go in and you have some work done and you pay out of pocket for that medical attention that you've had, there's a theory here, because the practice is really a tough one, that they can't let your health plan know that you've had that work done. You've got the right to privacy about that health care. There's accounting for certain disclosures of PHI in there, and I think you're going to talk a little bit about that as well. Amended marketing rules, which I'm going to cover in a few minutes. There's an opportunity to opt out of fundraising, and of course this would go to your notice of privacy practices and things like that. Enhanced business associate provisions. I think that this section, you know, the business associates, is a huge change. And I remember the first wave of HIPAA, everybody wanted to be a business associate. We had business associate agreements flying everywhere. And now the exercise is, oh, I'm not a business associate. No, you got that wrong. I'm not really a business associate. Please take this contract back. And then the analysis of whether you are or not, it becomes very serious. And we'll talk about the reasons for that in a little bit. Notifications for breaches, wow, that's huge, and it's really changed the industry, I think, in many, many ways. Restrictions on sales of PHI and EHR, electronic health records. Enhanced enforcement, and we're seeing that. We're seeing the enforcement. We're seeing the attorneys general around the country flexing their muscles collectively and enforcing HIPAA, and that's a huge change. And then there's a limited data sets and trying to figure out how the minimum necessary rule is going to relate to this. So that's sort of the high level, and that's and you may have questions about some of that, and I'm sure we can come back and talk about that. Well, let's talk about the business associates agreements, because it's a struggle, I know, for a lot of people to get these in place. The reason why nobody wants to sign, or they're not business associates any longer, is because the security and privacy regulations are now going to apply directly to business associates. Actually, a lot of the comments came out, they said, well, why do we have these agreements at all anymore if it's going to have a direct application? The comments, I don't know if, I think that they want to have a contract, and they want to have the contractual provisions. They want to get you to sign something together. I guess in theory you could have direct application to business associates. They've got to comply with the administrative, technical, and physical security controls. And also the documentation requirements. They have to have policies, procedures. So they're basically a business associate is basically standing in the same place as a covered entity with regard to some of these provisions. And of course, they are now subject to the same criminal and civil enforcement requirements. The definition has been expanded a little bit. And of course, for those of you that are at HIPAA 101 in here, business associate is an entity that does something on behalf of a covered entity, on behalf of a healthcare plan, a healthcare provider that uses standard HIPAA transactions and a clearinghouse. And they're processing or handling information on behalf and doing something for one of those covered entities. And there's a lot of little rules and detail in here that I'm not going to go into today, but if you are doing something on behalf, you're supposed to enter into this agreement. I should have actually started with that. And I apologize for those of you that don't know what a business associate is. But now it's more than it was, because it includes these regional health exchanges that are popping up. And that raises a bunch of issues, because how are they going to be business associates? What type of entity? If it's just passing information through and not holding it, is it still going to be a business associate? Some of these questions haven't been answered yet. E-prescribing, regional health information exchange, organizations, HIEs are all in there as well. And any vendor that contracts with a covered entity to allow the covered entity to offer a personal health record, a PHR. And PHR, if you're actually working for a covered entity, doing something on behalf of the covered entity, it makes sense that you would be a business associate. So those are the basic changes to the rule. I think the reality of it is it's easy to say you're now a business associate, but what you really have to do as an organization is put together a compliance plan. How are you going to go out and find your business associates is a huge challenge. I know that a lot of times, again, because willy-nilly we were throwing business associate contracts. We had people that weren't in the legal department entering into business associate agreements, or even in the contracting department. They were just popping up. People were giving a covered entity a document and saying, sign this, I can't talk to you until I do. So tracking them and knowing who these business associates are is a very, very big deal. And if you haven't started that process, it's a really good idea to try to do an accounting of your business associates and go through the analysis to decide which ones really are business associates and which are not. And that actually goes to another aspect of being a healthcare provider. You have to manage your business associates now. And the rule doesn't say you have to be their policeman, but you have to, vendor management is a huge issue anyway, and it has been for a long time. So by going through and doing your accounting of your business associates, putting all of, excuse me, all of those records, now the microphone's on, right? Putting all those records into place, having them handy for you, and that you can go back and look at them, know when they need to be renewed, all of those types of things is part of vendor management. So you need to look at that, manage that within your organization, and extend that maybe. Maybe you do want to go in and take a look and audit compliance, or especially if it's a sensitive business associate that's working on very sensitive information on your behalf. And think about it in terms of not just complying with high tech, but an overall vendor management program within your organization. And make sure that all of the, I'm seeing in my job at SRA, I'm seeing all kinds of versions of business associate agreements. Some have high-tech provisions, some don't, some have half of them, some don't have anything about notification. And so we're going to have the same battle of the forms and the issues that we did through the first wave of HIPAA. And so you have to be aware of that. And then you know, the designation, I already talked about that, and then the compliance. So these are the things that you should be thinking about as you do your business associate changes and as you wait for high tech to finally come out in its final form. Let's talk about another area, marketing area, which causes a lot of confusion, and there's been some changes in that. In the old days, well, actually it's still right now today because the final, the final have not come out, but marketing is a user disclosure of PHI for, to try to get somebody to buy whatever it is that you're selling, to give it to them. And there's a new definition for that. But there was an exception for face-to-face communications, promotional gifts, and nominal value. And then there were exceptions, so-called exceptions under the healthcare operations rule. So they moved all that kind of stuff around, and I'm going to go step by step through it fairly quickly, but it's a very complicated rule the way that it's written, so I'll see if I can walk it through and give you an idea of what it means to a covered entity at this time. First of all, let's start with basic definitions. Remuneration, key definition, is the direct or indirect payment from or on behalf of a third party whose product or service is being described. So it has to be direct, it could be indirect payment. That causes trouble, causes analytical problems. Is the person getting paid for making a communication or not? We can talk a little bit about that in a second. And it has to be from a third party on behalf of that or on behalf of that third party, and the third party's product is being described. So if you had a third party that comes in and they want to send out to patients some product that they're selling, some new face cream or something, that would be marketing. It would be a marketing type of situation. Treatment is, and again, this hasn't changed, the provision, coordination, or management of healthcare and related service by healthcare providers, including the coordination or management of healthcare by a healthcare provider with a third party, consultation between healthcare providers relating to a patient, and the referral of patients. All of those are treatment. So those are basic definitions, and I'll show you how we weave them in here. The new marketing rule says it's to make a communication about a product or service that encourages recipients of the communication to purchase or use a product or service. So that's the basic marketing definition. Now, there are exceptions to that. And of course, treatment is still an exception like it was before. So you can even receive, as a healthcare provider, remuneration in exchange for making a treatment communication about a health-related product or service. There's a couple of things that we'll talk about in just a second. But let's use refill reminders as an example. That's in the rule. So you can say, hey, Joe Smith, it's time for you to refill your prescription. And that's okay under the marketing rule. But the remuneration has to be reasonable. The amount of money that say the CVS is paying the healthcare provider to make those kinds of communications has to be a reasonable amount of money. And then there's some exceptions for unremunerated healthcare marketing, and it's the old operations communications. And let me describe those a little bit. If there's no money being exchanged, what you can do is you can make a marketing communication that describes health-related products or service, or payments for those products or service that are provided by or included in a plan of benefits. That's under the health care plan. This includes communication describing a provider network or plan network, or case management or case coordination, or plan enhancements or replacements, health-related products or services available only to members that are value-added. And it also allows you to make these types of communications for case management or care coordination. So if it's unremunerated, you're allowed to do that under the marketing rule. So if we go back and we look at it again another way, marketing includes communications about a product or service that's intended to get the person to buy the product or service that are not included in the exceptions that I talked about, and that are otherwise found in the exceptions, but no money is being exchanged. You're also allowed to have the face-to-face communications in the current marketing rule as well. So what do you do if you're going to do marketing? And some organizations are going to do it. There's going to be remuneration. There's going to be payment for making a communication to a person, and you use health information to make that communication. The name, address, know that the person's gotten a certain type of treatment. Well, what you do is you get authorization for that. And you need to have authorization if it doesn't fall in the exceptions, unless it's face-to-face or it's a promotional gift, just like the current rule. And then you need to go deeper than that. Not only get the authorization, but you also need to change your notice of privacy practices and make sure that there's an opportunity to opt out from using your name for marketing purposes. And you have to disclose financial remuneration in the communications. So you can still do it, but you need the authorization, and you need to be able to let people know through your notice of privacy practices what's going on. So we got 5 things here too, and we all know there's more than 5 things, but these are the top 5 that I've seen out there. You want to know if your organization is providing communications to persons involving the use or disclosure of PHI. If your organization is doing it, can you categorize these communications as either marketing or not marketing meaning an exception? Has the organization identified when direct or indirect remuneration is exchanged for the communication? This indirect, and I don't want to go into a lot of detail, but that can be very tricky. What happens if you have a healthcare provider and a pharmacy working together, and how much money is being paid to do, and you're seeing more and more of this, right? You're getting calls from your health plan saying, use this pharmacy, go to the Minute Clinic or whatever they have. This stuff is going on. So the question is there indirect remuneration? There may not be direct. Is it okay to pay for the printing costs? Is it okay to pay a little money for the preparation of the brochures that go out? Those things have to be looked at. And then your authorization forms have to be updated. Your notice of privacy practices have to be updated. And then you have to make sure at the bottom of it, if there is remuneration, is it actually the sale of PHI, which is prohibited under the new rules? And so you have to make sure that that's not the case as well. So those are the 2 areas that I chose to talk about, and the 10 things to be looking at. I'm going to turn it over to Derek now, who's going to carry on the tradition here. Thank you.
Yes. Thanks so much, Peter. So we're going to switch gears a little bit and talk about kind of a range of things in a, again, high level and kind of a quick fashion, but I'm sure we'll give you opportunity to ask some questions at the end here. The first thing, just really tailing on to what Peter was talking about in terms of being in an interim world, you know, none could be more true than the breach notification within the new HITECH rule. And we thought we were there with the final rule, but then it was withdrawn, and it was withdrawn on the basis that the whole determination of harm to an individual was somehow bestowed onto the covered entity or business associate. And I guess somebody was a little concerned that that was the fox guarding the chicken house and all of that. Might pop a couple in his mouth. So anyway, we have reverted back to the interim rule, and that said, there's still a lot of meat on that. And for us, in talking with a lot of our clients and working through a lot of the HITECH issues, we get a lot of obvious concern and question over a range of how does this affect us and what do we do if we are affected. So we're going to talk a little bit about that, and one of the things we try to do in this really complex wonder of webs is to try to make it simple. And you know, there are definitely a couple of get out of jail free cards that can be executed here. I want to make sure that we're all aware of those. You know, one of the provisions within the breach notification is that there is a recognition finally, as opposed to HIPAA, that encryption under certain levels and standards can be secure, can secure your PHI. And so, in other words, if you've got this laptop that we're absolutely sure we have PGP whole disk encryption, or it is absolutely locked down and is lost, you might have a loss of PHI, but you do not have breach, and you're not required to go and notify HHS. So things like that are things that you want to be aware of, so that you don't inadvertently throw yourself out to the wolves, so to speak, and you know, find yourself in a redaction situation later, meaning I didn't mean that, sorry. So what we've done to try to help you is put in place a very simple workflow diagram. I know it's very small. If you would like a bigger picture of this, I think we can certainly get that to you. Leave your business card for us at the end. But it really walks through some of the key points when you think that your organization has a breach on their hands. I mean, the first thing you've got to ask yourself, as I just mentioned before, is, was it secure? Is it encrypted? Did we somehow have a wrapper around that PHI so that it wasn't really a breach? So you want to obviously involve your chief security officer, IT, in that determination, and make sure we have the documentation to support that. The other is to make double sure that it was an inappropriate use of PHI. We get this a tremendous amount. I hate to say, you know, both in-house from admins asking the question, is it okay for me to send you, who sits right next to me in the same organization, this very confidential piece of information? I'm going, yeah, I wrote that. You can give it back to me. So you've got, you know, situations like that. You want to make sure that it was inappropriate before you ring the bell. And then finally, the bigger diamond down there describes some explicit exceptions that the regulations have put out there, and they refer to the inadvertent disclosure of PHI to, as I just mentioned, a workforce member. We know that that's okay. If you are in contract or in an agreement between two covered entities or a business associate or a combination of both, and we have that good business associate agreement in place, and you inadvertently send a little too much information over to the other, was that a breach? No, it wasn't, as long as you're in that agreement. And then the final is what always makes me laugh, a inadvertent disclosure to a individual, a person, and they didn't have any, and we don't believe in good faith evaluation that they had any ability to retain that information. So the likelihood of it getting further disclosed, very low. I can only envision talking to a baby, and I'm pretty darn sure that they wouldn't get it. So couldn't come up with a better example than that, but we want to guard against things like that. Another real quick thing, if you've gone through that whole process of doing a risk evaluation and you find that, yes, indeed, I've got to go ahead and record the disclosure, then here is the wonderful site that HHS provides us to go ahead and log that breach. And it's a very simple form, as you can tell. It looks very e-commerce-like. Couple of hot tips. It's not really sophisticated, okay? You go ahead and fill this whole thing out and submit it, and you go, oh, I forgot something. Too bad. Gone. Gone. You get no receipt. You have no reference number. So I recommend print it out, copy it, put it somewhere safe. So just a little tip from me to you. Switching gears one more time, and kind of traversing into the other side of high tech for a bit. I know that we could get into this whole EHR meaningful use and spend another hour or two on this, but there are definitely some interesting points to bring up, because a lot of what we do definitely is on risk, privacy, security. We do technology as well. But we haven't done a lot of the implementation and meaningful use stuff per se with our clients. However, we're having a lot of our clients who are in that process of taking advantage of the stimulus funds from ARRA and HITECH to implement meaningful use of EHR. And what they're coming back to us on is, we need to do a risk assessment. We've got some issues here on access controls. We thought the big problem was going to be tying the systems together. No, it's really controlling access to those systems and ensuring the security of the data transfer and such. And so, you know, this diagram, just to give you a visual snapshot of what you're looking at, really is kind of a simplistic view from a provider perspective, let's say, since that's what this EHR incentive really refers to. And you look at all of the data input points, from capturing the patient record and the demographics to now exposing that over to the clinical team who's going to evaluate you, knowing some of your background, add to your medical record, and then just drive it deeper. Then we're going to subject all of that to automated decision support, possibly further communication to other care providers. And ultimately, if you look at this, this is just for one entity. Within ARRA and HITECH, of course, there's the provision of implementation and incentives for health information exchanges. So the ability to now ubiquitously exchange all of this information between government entities, other care providers, other folks within the care continuum, to hopefully bring a higher level of quality to your individual care. And that's all wonderful as long as it's secure. So just for those of you who aren't following this or aren't really familiar and want a thumbnail, this is a quick snapshot from HIMSS of what the various stages of EHR implementation include. And it seems somewhat random at first, but from the clinical perspective, it definitely had, it basically reflected all of the low-hanging fruit out there in terms of getting systems to talk with each other, aggregation of the patient record, and then doing something with it. And besides just scanning pictures of charts in and saying, you know, I'm electronic, you actually have to do something with the data. And then the lower box there reflects the dollar incentives to the individual providers. For hospitals, larger facilities, the incentive starts at $2 million and can go up from there. But as I said previously, what we're being called out on is right at stage 1, which is where we're squarely in the middle of. Arguably, some should be wrapping up stage 1 and moving on, but there is an absolute requirement for a risk assessment of your EHR at stage 1, and that's what folks are getting hung up on. So in terms of doing a risk assessment, again, to help those folks out there who are interested in what the general steps are, they're not mysterious, and I think they're almost intuitive. You go through the standard 4 steps of doing a discovery, assessing what you've found, create your gap analysis, do recommendations, review, and then the key part is to make sure that it finds its way into an ongoing risk assessment plan or internal audit plan so that you stay with it. And this is something that in the last year and a half or so has become a real hotbed, I think, not only for HIPAA and HITECH, but certainly the range of other regulatory environments, SOX, PIPEDA if you're in Canada, etc. And there's always this baseline requirement now for risk assessment. I think up to this point, folks would do it maybe once. I think the interesting study from CMS, where they went out there to poll folks that had supposedly done risk assessment, they themselves admitted they fudged the whole thing. We knew what the pain areas were, so we didn't include them in that risk evaluation. We did half of the risk evaluation because I don't have a good relationship with IT, etc. And so what you want to do is be honest, be comprehensive, and most of all, as you go down and come up with your action plan, make sure that there is a plan to revisit it and check your progress on that annual, and you'll see whether your organization is indeed taking it seriously or not. These are the obvious things, of course, that you're going to include in that risk assessment, and as Peter had said, in particular with HITECH, high emphasis on the administrative, technical, and physical security aspects of the business associates and business and covered entities, rather. And we're really looking at making sure that we are actively anticipating threats here. We're not taking the checkbox approach and saying, yeah, okay, we'll put in antivirus, we'll go ahead and put in a firewall and let it run, and hopefully it will maintain itself. This is indeed how data breaches end up happening at the technical and security level. The final slide that I leave you with, as I was just touching on briefly and previously, is that many of the organizations that we work with clearly fall within the HIPAA and the HITECH bucket, but they also can fall into the other buckets as well. We have a lot of folks that are doing SOX and HIPAA, SOX, HIPAA, and Graham-Leach-Bliley. But the point to make here is that obviously this level of security and privacy, accountability, and compliance is not going away. It's not going to become less. It's probably going to become greater and much more broad spread. The fact of the matter, though, that is seeming to be good news is that everybody wants to rally around a standard, and that's good, because if your organization subscribes to high trust, which is, let's say, an amalgamation of the NIST standards and FISMA standards, then you're probably in line with what all of these compliance regulations are looking for. And you'll save yourself effort if you try to buck the trend and clip off a little here and there, and again, take the checklist approach, but not really indoctrinate it into your culture, then that's where you end up having the majority of your problems. So with that, we certainly appreciate all of your time this morning. It's been exciting. I know we probably don't have nearly enough time to cover all of these issues, but we do have some time for questions. I'll go ahead and moderate the questions. Yes, back there.
Hi, Peter.
Okay.
I have a question. Military health care and TRICARE and the Veterans Affairs, are they considered covered entities because they are health care providers?
Did you all hear the question?
Did you?
TRICARE, what was the rest of it, Ken?
TRICARE, Military Health Services, and the Veterans Affairs, are they considered covered entities?
Yes.
Okay, thank you.
Yes, sir.
Hi, I'm Joanne Klein. I was wondering what the panelists think of the recent OCR enforcement activity, the penalties that we saw in recent weeks, and also the settlements.
That's a great question, and it has been the subject of many informal conversations in the last day. The OCR actions that is being spoken of really occurred over the last week or so, and they were pretty much back-to-back. One of them was for Signet, a plan, and basically they got slapped with a $4.3 million fine because they basically denied about 40, I think it was 41 exactly, individuals access to their medical records, but they exacerbated the problem by not cooperating with OCR. Didn't want to cooperate with the corrective action plan, didn't want to give them the records. And so for Signet, I don't know if they were just trying to test the waters and see if they were serious or not. I think they found out they were pretty serious. The other one that came out was for Mass General, and this was a very common case, 192 patient records in paper format. The individual wanted to work on them at home, took them on the subway, left them on the subway. So I don't know how that actually happened. That's still a good stack of paper. But anyway, I think our take on it after, and this is just kind of collaborative take, is certainly I think it was, as OCR director have put it, we hope that this shows people that OCR is serious about HIPAA enforcement. And so she said it plainly, and I think that that is the take.
Building on that, I heard a healthcare professional urge his colleagues to err on the side of being conservative, specifically with notification, simply because the backlog of investigation by OCR is longer than 60 days. So, I understand your trade-off where you're deciding whether or not to report, but to not report is to take a gamble that OCR will decide if you were right. And they will get around to deciding if you were right after the deadline to do anything about it has passed. Can you comment on that, just in terms of erring on the side of being conservative with respect to notification?
Right, and I think that that's what I was, in part at least, trying to illustrate with the risk assessment workflow. You want to be sure. If you actually do have a breach, though, you definitely want to report it. You don't want to have it come back on you and say, well, you did the assessment and you found out that you did in fact have a breach, but you thought that we wouldn't see it. So that's probably risky. But on the other hand, not being reactive is really prudent. And we've seen it with many of our clients. Somebody runs up to compliance and screams green. The compliance officer looks at it and goes, no, this was an internal communication. You go, oh, gee, I already sent an email to someone, telling them we had a breach. And so, yeah, you don't want to do that. Anything else? Yes, ma'am.
Sort of related to that, it's my understanding that the BAA, or the business associate, has up to 60 days to make this determination and report to the covered entity of the breach. And the covered entity that I'm associated with is considering in the business associate agreement to lessen these 60 days to 30 days to make that determination by the business associate. Then we've had the feedback on that.
Yeah. First of all, the 60 days, I think if it's an agent of the covered entity, if it's that type of, rather than an independent contractor, if you're an agent, it's supposed to be faster. Yeah.
Context of independent contractor.
Yeah, but you can alter if you go more conservatively. And that if you go that direction, you can certainly change the contract terms and make them report sooner. It's part of that management of your business associates. Now, whether they'll sign that or agree with you on that, that's always something that you have to work through.
Well, I was wondering if the result of that might be that the business associate would over-report rather than take the time to determine was.
Oh, that's probably true. Yeah. I mean, it could definitely end up being that. And I think it's very, the investigation part is very important. I think it's built into the whole concept of breach notification, that you have the right to look into it to determine whether the breach occurred or didn't occur, whether it was a breach under this set of regulations, and they're very different than the other breach, so there's a lot of issues that you have to look at. But yeah, I guess you could run the risk of doing that. But then again, if you have a business associate you don't, I wouldn't say don't trust, but you've had some bad things happen in the past, going that direction and having them over-report may not be a bad thing, because they may not be capable of doing those types of analytical measures that you can do. So, maybe you can step in and help them. So.
There was another question there earlier.
What have you heard about the status of OCR audits and the audit guidelines?
The status of OCR guidelines?
Audits.
We, from my perspective, and maybe you've heard something different, we have not heard anything finite. There are no specific actions. They just talk in general terms that they are up to it and are gearing up for it, etc. I mean, of course, what we do know is that they're mandated by the latest regs and they're funded. Finally, maybe not lots, but they're funded. But the one little proviso in there that is interesting, and I hope I'm not, bringing bad juju down on us, but there is also the statement within the regulations that says that that OCR can basically replow any of the monetary gains that they get from their audits back into their own department. So if they're running a little shy on their budget, that may be a way to get some money. Yes.
As a health plan, we insure Medicare members as well, and we have run into an interesting scenario, or I guess almost like a dichotomy, where we have the high-tech provisions, where we have the 60 as soon as reasonably possible, up to 60 days to report and to notify a member, and then, but within our CMS contract and the expectations within the Medicare program, they expect that we will report to them within 2 business days. And depending upon how you read that 2 business days, it could be for an egregious act or it could be for anything that's considered a breach. And within 2 days, you don't necessarily know if it is in fact a breach. That's clearly, we're talking about a very challenging experience trying to pull all that together. Wondering if from your experiences, if you've run into this situation or have any thoughts about that?
Certainly ran into it at United Health Group. In fact, the gentleman sitting right next to you, it would be able to give you some really good insights into that, because he handles all the breaches for UHG. There's even more than what CMS is doing. I mean, the Department of Insurance for Connecticut has a 5-day window as well. And you're completely correct that it really, and you talk about over-reporting, I think a lot of times in a health plan situation, if you're doing Medicare as well, and you have something happen, I think it results in over-reporting because you don't want to cross CMS because you rely on them so much for your business. And so I don't know if that's been your experience where you just don't, you just report, and you may report, we're still investigating, but we want you to know about this.
Well, we actually had a scenario where our business associate did their due diligence over a period of time. Then we were notified, and then we weren't satisfied with the responses we got from our business associate. So we had to do a little bit back and forth. So by the time we were able to identify it truly was a breach, it certainly was beyond 2 business days. And CMS was not thrilled with the delay in notice.
Yeah. You leave that on the subway, right?
Oh, I hear
Your
that
iPad.
all the time. Wish I could find one. Anyway, great question. And so the first part of it, I would say, there's nothing by way of regulation that I know of that's coming down the pipe that is as specific to portable devices as you were stating. That said, we certainly talk about within the regulations the storage and the transport, et cetera, of protected health information, confidential information. But from a best practice perspective, what we see out in the market, what we advise, is that especially in the clinical arena that you're speaking of, there's no question that there is a real hotbed of development for iPad applications, for example. And the fact of the matter is the health systems can't sit there and just deny the portable devices. So what you do need to do is take the other approach, which is to legitimize them and say it is specifically this standard and that standard, and put them under your IT's control, under your policy and procedure control, and that really is kind of the best that you can do at this point. And
one of the major problems is these devices don't support encryption, they don't support VPN, they don't support most of the fundamental security things that you would put on an application in order to secure them.
Right. Yeah, that by and large is true, but I can tell you a lot of people are working on that particular issue. I was out at HIMSS a couple of weeks ago, and there are some kind of neat and compelling things coming for the portable devices. There is decent, strong encryption for iPhone, iPad coming. Android's lacking a little bit. But then there are also the mechanisms, and this is why it needs to be legitimized within your organization, to actively track the agents that we can put on the devices to wipe them clean remotely if you end up with somebody that goes rogue. Yes, sir.
Regarding the issue of whether under high-tech VAA is even necessary, do you think that covered entities need to think about whether entering into a VAA potentially exposes them to greater liability, because now they're getting themselves on the hook potentially for monitoring a business associate closely, setting out the terms, or do you think just a course of prudence to do it?
I didn't want to lead all of us down the path that the business associate agreement isn't necessary. It's just, if you compare it to FISMA, the Federal Information Security Management Act, FISMA is not a direct application to contractors. You have to flow through agencies to get there. And that's how HIPAA used to be. You had to flow through from a covered entity, have that contractual relationship out, and then you would get them under that contract. All of the discussion about managing your vendors and all that really goes to the idea of having a contract. Even though there's now direct application by way of law, directly to the business associates, or at least it's coming in final form. But you really, and depending on your site, you really need to manage your vendors, your outsiders, your business associates, whoever's doing this work for you. And the only way to do that is a contract. And if you want to monitor them and do the things that you do for vendor management, it will be a contract, because that's done in the regulations. And then you want downstream. You want the business associate or business associates also to be brought under that as well. So I maybe it's a lawyer in me, but I think it's good to have a contract with the legal laws there. I was just saying that a lot of the comments that you saw when the NPRM came out, people were saying, well, why do we need it?
You have time for just a couple more questions. Yes.
Well, I want to comment on this woman's question on the security of mobile devices. I'm not in sales, but I do work for a company that actually sells that technology for iPhones, iPads, Android, and Blackberries.
You're very popular.
Jennifer Hatter.
There you go.
Good play. Anyone else? Other than that, no more questions. Well, thank you very much for your time today.